The smartest people in Silicon Valley have spent the last 20 years trying to figure out how to stop their patent lawsuits from being heard in a town that is roughly the size of a community college. The town is Marshall, Texas. Population 23,309. It has one Walmart. It has a brass band that performs at Christmas. And from approximately 2010 until 2017, somewhere around 25% of every patent infringement lawsuit filed in the United States of America was filed inside its modest two-story federal courthouse. I asked my writers to find the closest Apple store to Marshall, Texas. They came back 2 hours later with the answer, Shreveport, Louisiana, which is 80 miles east, in a different state. So the question is how a town with no Apple store became the place where Apple gets sued. And the answer is one federal judge with a chess clock. In 1999, a man named T. John Ward took a seat on the United States District Court for the Eastern District of Texas. Marshall is the seat of Harrison County, and the courthouse there was assigned to him. At the time, the Eastern District handled almost no patent cases at all. It was a quiet, rural docket, mostly small business disputes, the occasional federal drug case, and the kind of slow-paced civil work you would expect from a town whose biggest annual event was the local holiday parade. Judge Ward decided to speed things up. He wrote local rules that capped the length of every motion. He punished lawyers who abused discovery. And in the courtroom, he used what is technically called a chess clock to enforce strict time limits on every lawyer who got to speak. Each side got the same allotment. The clock ticked down while they argued, and when it ran out, they sat down, whether or not they were finished. This was a small procedural innovation. It was also catastrophic for everyone in the rest of the country. Here is what happens when patent litigation gets faster. Patent infringement lawsuits are extremely expensive to defend. Millions of dollars in lawyer time, millions in expert witnesses, millions in document discovery. The longer the case drags on, the more the defendant pays. Most of the time, defendants do not actually want to fight a patent lawsuit on the merits. They want to settle, because settling is cheaper than 2 more years of paying $800 an hour to a Boston law firm. A fast docket changes the math. If you are the plaintiff and you can credibly threaten a trial in 18 months instead of 5 years, you have just made yourself enormously more valuable as a plaintiff. The defendant either settles fast or fights fast. Either way the case clears, the patent law firms noticed. Then the patent assertion entities noticed. Those are the companies that exist solely to acquire patents and sue people with them. Then the rest of the country noticed. By 2015, the Eastern District of Texas was handling 43.6% of every patent case filed in the United States. 43.6% of the entire country in a single rural district. One judge alone. Judge Rodney Gilstrap, who succeeded Ward in 2011, was personally responsible for around a quarter of every patent case in America. The Stanford Law amicus brief that produced this number had to triple-check the math, which my writers have informed me is the standard reaction of every law professor who has ever encountered Marshall, Texas. The lawsuits got loud. There is a company called VirnetX whose primary business activity is suing other companies for patents. They won $368 million from Apple in 2013. Then $626 million more in 2016 over a patent related to FaceTime and iMessage. Then another $502 million in 2019. Samsung was sued in Marshall. Motorola was sued in Marshall. Dell was sued in Marshall. Hewlett-Packard was sued in Marshall. The McCool-Smith law firm opened a Marshall office to be physically present in the building where the cases were being heard. Because you cannot file a brief by Federal Express if the judge wants it on his desk by 4 p.m. and Federal Express stops delivering at 3. A microeconomy developed. Hotels expanded to handle Bay Area lawyers. The local Sonic Drive-In started taking conference call orders. Local jurors became in patent law circles the most studied juror pool in America. Plaintiff attorneys reportedly conducted focus groups with locals about how they felt about big technology companies, the answers to which are mostly available in the public record, and mostly very colorful. And then in 2017, the Supreme Court decided it had finally had enough. The case was TC Heartland versus Kraft Foods. Decided in May, the court ruled that for patent cases, venue must be the district where the defendant resides, defined as the state where the company is incorporated. Apple is incorporated in California. Most defendants were also not in fact incorporated in East Texas, so most cases that had been getting filed in Marshall could no longer be filed there. In the year before TC Heartland, the Eastern District of Texas handled 38% of U.S. patent cases. In the year after, it handled 13. About 820 cases moved out. Delaware picked up most of them, because that is where most American companies are technically incorporated, which is a separate story for a separate video. So Marshall is still a small East Texas town with a federal courthouse. But the patent docket has been cut by roughly 2/3. The McCool-Smith office is still there. The Sam B. Hall Jr. Federal Courthouse is still there. Judge Gilstrap is still there, still doing his job. still managing the cases that survived the new venue rules. The chess clock is presumably also still there. And somewhere in the state of California, an Apple corporate counsel can now file a motion in a court he can drive to without getting on an airplane, which I am told is a luxury Apple's litigators had stopped expecting.